ladies and gentlemen, please be seated. All right, before we get started, and we're mid-witness, but I did want to address both jury panels at this time, all right? I know everyone listens differently and listens to testimony. You know, you could maybe leave your head to the side, close your eyes, do something and still be listening. But we're also watching you as jurors, and we want to make sure that everyone's paying attention. If your eyes are closed, we don't know whether or not you are listening, okay? So I'm going to ask that you please keep your eyes open, and obviously that doesn't include blinking or whatever, just kind of our natural things, but there's obviously a lot at stake for everybody involved in this case, so please do everything you can to remain cognizant, and if that means during a break you raise your hand and you say, I gotta go get a cup of coffee, you gotta let me out of that jury room, I prefer to hear that, okay? All right, the next thing I wanna address is that we also have to remember that we are to have no contact with anybody that's smiling at anyone outside of your jurors and your peers that are with you. The panel should not be talking with each other, and there's a lot going on here logistically. We've talked about that ad nauseum at this point. Be very careful about who you're talking in front of and who is around you and who you are communicating with, okay? All right.
Case number 2024-291-950 FC, and People versus Carlos Hernandez, case number 2024-291-945 FC.
John Petrofessa and Andrew McGarrow on behalf of the people.
Good afternoon, Your Honor. Michael McCarthy, P30169, appearing on behalf of the Joshua Zuazo. Mr. Zuazo is standing to my left.
All right.
Hello, Michelle Lawson on behalf of Carlos Hernandez, who's standing to my right.
Okay, all right. I see everyone. Welcome back. We have to address a juror. The court did receive an email, and you guys can be seated now. The court did have an off-the-record conversation with the attorneys just to let them know that today on October 2nd, 2025 at 1:12 p.m. I was in my chambers. An email came through from who I believe is a juror in juror pool B. I do believe he's juror in seat 2. I'll read, I've already discussed the contents of it with the attorneys. I'll read it on the record once juror in seat 2 is here so everyone can hear the correspondence, as there could be no private communication between the court and the jurors at this time. All right, let's bring in then in jury pool B, seat 2. Hi there, juror pool B, seat 2. Have a seat, sir.
Okay.
All right, well, I mean, I had an off-the-record conversation with the lawyers about the email that you sent to me. I mean, I can't express my level of frustration enough. All right, I think I made it very clear through all my instructions throughout that there should be no communication whatsoever with anyone involved in this case. That also includes me. All right, you are a sworn juror. That is a very important task. So all the parties need to be aware of what the email says, so I'm going to read it into the record so that everyone is aware. The email was received today, October 2nd, 2025 at 1:12 p.m. It says, Your Honor, it is an honor being chosen to participate in doing my duty as a citizen in your courtroom. I am a juror in Juror Pool B in this week's case. However, I wanted to send you a formal complaint about the juror handling. Tuesday and Wednesday, I've asked about receiving some sort of jury schedule so I could accommodate my work and personal life outside of court. They said they'll let me know. No reply, no recognition to the question. Thursday, today, during the beginning of today's trial in the morning, I was very hot and sweating in the courtroom. Luckily, you called an early 20-minute break. I asked the handler if I can go really quick to my car to change out of a shirt that I had in my car. The handler said, give me 5 minutes, I'll let you know. She never came back and only came back to let us back in the courtroom. I told her, why did you ignore me? And she said, oh, you can't go until lunch. I said, you said you'd let me know in 5 minutes. We've been on break for about 30 minutes where I could have changed my shirt. She replies, I'm letting you know now. Clearly, my comfort hygiene in the courtroom is not her priority, nor my question. The juror handling experience personally has been very poor and not considerate of any questions or requests. At the end of the day, I was chosen to be a juror, and I'm happy to do my duty, but anytime I've asked the personnel a question or a request, they've essentially ignored. They only speak to you to let you in and out of the room. Thank you for your attention to this matter, and you signed your name to it, sir. I'm not going to read your name into the record as of right now due to the court indicating that I would only call jurors by their seat number, and that's for purposes of judicial economy, so juror in seat 2 has signed this. All right, so there's a lot of questions that come from this, all right? So I guess to be clear, the members that are helping jurors come in and out are employees of the courthouse. They are not handlers. I instruct them to ensure that the jurors remain in a safe place and together. And we discussed the possibility of security concerns regarding my hallway, having 2 additional chambers. Those individuals don't have the capacity or frankly, they're not in a position to allow you to go to your car. It is not something that they are personally holding against you. They're simply following the court's instruction. I was also clear about my instruction that there should be no communication with those persons. If there's anything that needed to be communicated with, it would be in the courtroom, in the presence of everyone. As there could be no conversations had among anyone unless it's out here where we're video recording and everything I'm saying is on the record right now, okay? So it's not a personal attack on you, but there's concerns now based on the fact that you sent me an email. I know my email is readily available online. My assumption is in order to get my email, you would have to Google me to get that. So our number 1 question here is, how did you receive my email address?
Through the internet.
Okay, so you did use your electronic device then to search my name?
Yes.
And based on that search, what information, if any, were you able to retrieve?
Just your email on like a directory kind of page?
Was that on the Oakland County page?
Yes.
All right. Was there anything else associated with this court or my name that came up in that internet search as it relates to this case?
No.
Okay. All right. So before I let the lawyers ask questions, because they have a right to do it, do you understand everything I've shared with you as to why there could not be a release at the time, even though you asked for it and even though you're asking for certain information to be communicated with me? Do you understand why that's not being done?
I understand I was wrong in the procedure of contacting you in general. But I thought if there was something during the court that you said, let the person know if you really got to leave the room or do so, let them know. So
Okay, so
and I
maybe
thought
there
on
could be some confusion about that. I agree. I know I've said like you can raise your hand. I'm basically saying with me though, because we're all out here together, there should be no communication with those people. Their job is to make sure that you guys are safe and kept together, and they're following the court's instructions. All right, you can be seated. Before we bring back in the jury panels, obviously, Mr. Zlazo it's not his juror, so I don't know if there's going to be a position taken, but I'll hear positions from either parties regarding juror seat number 2 remaining. I will tell you my thoughts. My thoughts are, is the court is confident that this email was in no way biased towards one party or another. It didn't say anything like we had a situation with another juror that obviously we're all aware of, like I know a family member or I can't be fair. This is someone simply complaining about the process, being potentially new to the process. Myself and the lawyers are obviously doing this all of the time. It sounds like this is something new to the individual who thought that it would be a good idea to reach out to the court, but I don't think that biases the person for one side or another. I do believe juror seat number 2 when he says that by Googling the court, the only thing that appeared would be not news stories associated with this case. I don't think that's uncommon. I think that it's likely that if you were to Google me right now, the first thing that's going to show up is the Oakland County Directory, and then potentially other articles of other matters that I've been involved in. I don't think the news stories and the court's name have caught up to each other at this time. Of course, I could be wrong, so I'll hear from everybody.
People agree with what the court just indicated?
May I have a few moments to
Sure.
confer with my client? Your Honor, I have had enough time to speak with my client, although I do believe he had inappropriate contact and did outside research. My client is desiring to keep him as a juror.
Okay, all right, does your client want me to address the other jurors in that panel to see if he's had any conversation with them about the Google? I know he indicated he didn't, but I'm happy to inquire if you see fit.
I think that may be appropriate.
Okay, all right, so let's just bring in jury in panel 2. B. All of B.
All rise for the jury.
Hi everyone, welcome back. Please be seated. All right, as you can see, you're the only jury in here right now. We'll be bringing back the other panel momentarily, but I do have a question to this panel, and if you could just show me by a show of hands whether or not this occurred. It has come to our attention that potentially someone may have used the internet to Google information about this court. It was primarily done to receive contact information for the court. But I just want to know whether or not any of you have learned about that or had a conversation regarding what was either reviewed when that, if and when that was done. A show of hands? Yes, sir.
I looked up the word octatrillion just to figure it out, but I don't know if that was what you're talking about.
Okay, all right. Yes?
I looked at you.
Okay, all right, okay. We cannot do that, all right? So if you, sometimes the lawyers, as they've said to you and in my instructions, you are going to be curious about given to you through evidence, which is direct testimony, cross-examination testimony, or any exhibits admitted into evidence. A Google search as to what, I can't even say the word, is not appropriate. Because whatever that search gave, information it gave you, is not evidence. Are you going to be able to set that aside?
Yes.
Okay, and let me just say for the record, we're at 8, 9, 10, 11, 12, juror in C 12. All right, so what information when you Googled that word, can you tell me the word again?
I think it was the octatrillion.
Octatrillion. What did you learn when you Googled octatrillion?
It was a pretty big infinitive number.
Okay,
Meaning very, very way past a billion and trillion and all that.
okay,
I just never heard it and I was kind of trying to understand what it meant.
okay. That's exactly what we cannot do as jurors.
Sure.
Only information that we receive is received here in court. Okay?
Sure.
And then 4, 5, 6, you Googled me. To the court, basically. I was just wondering how long you've been a judge. Okay, all right. And I promise you we'll all get an opportunity to talk when we're done, and I can answer any questions about myself personally. When you looked up that information, did you see any newspaper articles or any news as it relates to this case? Okay. Be seated. Thoughts?
I have no concerns, Judge.
If I could have a moment to call appellate counsel, I'm not sure at this point. Obviously, a juror has admitted that he's doing outside research, and that gives me some pause.
Okay, and so let's just kind of break that down. I'll absolutely give you an opportunity to call appellate counsel. Juror in seat 2, we're all satisfied at this point, didn't talk to anybody else about his search, right?
Agreed.
Yes, Judge.
Okay. Juror 7, 1, 2, 3, 4, 5, 6. Juror 6 did a Google search of the court. And I'm also satisfied that the information that was received was essentially any directories or other, potentially other articles that the court's been involved in, but not in this case. Is everyone satisfied with
Agreed,
that?
Judge.
I agree. I actually looked up your name, and the first thing that came up was the Oakland County Circuit Court webpage, and I did not see any news stories on the first page.
Okay, and I'm glad you did that because that's my understanding as well. Your concern now is juror in seat 12's potential research regarding what that number is,
Yes.
and that he's otherwise admitted to that using an electronic device, which is contrary to what the jury instructions allows you to do in order to research a piece of evidence that was admitted in the trial. Okay, all right, so would you like your client, how long would you like a break for?
I would say just 5 to 10 minutes. I believe my contact would be available by phone, and I don't think it would be hard to reach her, so I just need to have a quick conversation.
Okay, all right, so we'll take a 5-minute break.
Sure.
I will go off the bench, but everyone else is gonna remain.
Understood.
Okay.
And I have permission to step outside?
Of course.
Thank you.
All rise. All rise.
All right, you may be seated. We don't need appearances, everyone's here. Ms. Lofton, what'd you learn?
Yes, thank you, Your Honor, for that break so I can confer with appellate counsel. And after speaking to my client, we are okay with keeping the juror that did the independent research. I would ask that he, again, be told that he cannot use the knowledge that he garnered during this independent search when he returns, if he is not an alternate, when he goes back and does his deliberations with the jury. And I would also ask or remind the jury that any questions they have are only to be tendered to the court through notes when deliberations begin.
Okay, I'm comfortable with that, people. Comfortable with that?
Judge, yeah, from what we just heard, it's a definition of a number and how many zeros are behind it. In fact, for follow-up, I'll ask Detective Conley tomorrow what octillion means, and that way it's actually on the record, the definition of that, so there's no additional information that he's garnered that won't be on the record.
Well, you're gonna have a difficult time determining what octatrillion it means, because that's the term that was used by the juror. He may have had a difficult time locating that.
I mean, what we all know, and I think everyone can feel comfortable, is that it is a universally large number that is infinite and that is not used in our everyday speech, as most of us cannot even pronounce it, right?
Yes, I would say so.
Okay, all right, let's bring in our jurors.
All rise for the jury, please.
Okay, please be seated. Ms. Lawson, I want to address you up here in front of everybody. Okay, ladies and gentlemen of the jury, I want to remind you that you are not to use electronic devices to communicate with the court, do any independent research on your own, even if it's things that you don't think are important. or don't think have anything to do with the case, researching the court, myself, or any of the attorneys, as you can inadvertently pull up a story that has something to do potentially with this case, and that would therefore make you an inappropriate juror. So we all have our cell phones, we always walk around with them, we all have them with us. They're not to be used unless they are used for something that has nothing to do with the court. So while you're here, don't use your electronic devices for any purpose other than answering your emails or communicating with family or friends, all right, during your breaks, okay? The other instruction I want to give at this time is if you have heard or learned any information outside of the court through research on your own through an electronic device, you must set aside any information that you learned. The only evidence that you are to consider when you go back to deliberate is evidence that was properly admitted into court. As I indicated previously, evidence that is properly admitted into court is evidence by witnesses who are sworn to tell the truth, that lawyers are able to cross-examine, and any other documents or exhibits or reference materials that the court admits into evidence. Nothing else is to be considered